to the parties as we prosecute the case, as we talk to more witnesses and talk to, in some cases, more co-defendants and cooperating witnesses. That's been the case in the prosecution of Jamarcus Johnson. As we told Your Honor in chambers, I think the court is aware, the state now understands the exact participation of Mr. Johnson in the conspiracy with regard to the murder and cover-up of the murder of Adolph Thornton Jr., known as Dolph in the community. Mr. Johnson Mr. Johnson, Jamarcus Johnson, had no involvement in the homicide before the murder. He had no involvement in the homicide during the murder. His involvement was after the fact. About a week after the murder of Adolph Thornton, his brother, Justin Johnson, who in fact was one of the shooters and one of the killers of Adolph Thornton Jr., came to him and gave him certain property. A car, not the car used in the murder, but nevertheless a car that Mr. Justin Johnson had possession of, and a cell phone. The cell phone was of particular importance because it was Justin Johnson's cell phone that he had during the murder and that he had used for some time before. This Mr. Johnson agreed to take possession of the car, and he agreed to take possession of the cell phone. His taking possession of the cell phone and the car aided in Mr. Justin Johnson's continued evasion from authorities and his continued cover-up of the conspiracy. This Mr. Johnson also used the telephone. He used the telephone by his brother Justin would call the telephone, and he'd place the telephone up to another telephone, and they would, in essence, trick Justin Johnson's federal probation officer into believing that Justin Johnson still had his cell phone and was still in Memphis, Tennessee, when in fact he had fled after murdering Adolph Thornton and was not in our community. He also did the same thing where he placed Justin Johnson's cell phone up to another cell phone, and he facilitated a conversation, again, this is over a week after the homicide, between his brother Justin Johnson and the other shooter of Adolph Thornton, Cornelius Smith. Mr. Johnson preserved the telephone and turned it over to authorities. He spoke with the state, and he's described the content of that conversation and the content of some text messages between Cornelius Smith and Justin Johnson that included Mr. Justin Johnson trying to get money to Cornelius Smith after the killing. Mr. Jamarcus Johnson has given truthful statements to the state with regard to all those acts. Those are 3 acts of an accessory after the fact that did aid in the cover-up and this conspiracy. For those reasons, now that we understand those to be the facts of his involvement, now that he's given a truthful statement with regard to these things, he has also identified a picture of his brother Justin Johnson wearing the outfit of one of the shooters of Dolph just directly before the homicide. Now that he's been 100% cooperative and truthful, we're asking Your Honor to accept a guilty plea and recommendation in the case. There's a criminal information that is before Your Honor. It has 3 counts. It's I-2300019. It alleges 3 counts of accessory after the fact for those 3 acts that I just described to the court: taking possession of the car, the cell phone, and then using the cell phone to facilitate those communications. Even though Mr. Johnson is a range 1 offender, he has no criminal history. He's agreeing by this guilty plea, which is open to the court, that he should be sentenced as a range 2 offender. These are E felonies. Range 2 for an E felony carries 2 to 4 years incarceration. He's pleading guilty to all 3 counts of the information to those 3 E felonies, 2 to 4 years incarceration. He's also agreeing that when Your Honor sentences him, that all 3 of those sentences should be consecutive to each other. So Mr. Johnson is in essence pleading guilty to the court, open to the court, to a sentence that can range between 6 and 12 years when Your Honor sentences Mr. Johnson.
Yes, sir.
The parties are not asking Your Honor to sentence Mr. Johnson presently or we're asking Your Honor to delay the matter, to reset it for sentencing.
Yes, sir.
There are conditions of release pending sentencing that are outlined in a separate sentencing memorandum which is filed with this guilty plea.
Yes, sir.
And at a later date, the state will request that Your Honor sentence Mr. Johnson. I've stated the facts at the start of the plea, so I ask for counsel to stipulate to the facts. I'll just very, very briefly, basically 2 or 3 yes or no questions asked of Your Honor, Mr. Johnson during the guilty plea.
Yes, sir.
I'll ask Your Honor to accept the plea after that.
Mr. Corman.
And Judge, I believe that would be the evidence the state would present in the case going to trial. We do stipulate there's a factual basis, and we're going to ask the court to accept our negotiated settlement.
Mr. Corman, Mr. Hagerman, thank you. Mr. Johnson, Marcus Johnson, come around, please, sir. Mr. Johnson, come up here where Deputy Chambers is. And once you get to the seal of Shelby County, put your left hand on the Bible and raise your right hand to be sworn, sir. Do you solemnly swear or affirm the testimony you will give this cause to be the truth, the whole truth, and nothing but the truth to help you God? Thank you, sir. Mr. Johnson, have a seat here on the witness stand, please, sir. Counsel, approach, please. Yes, sir. Deputy Chambers. I need your signature and my signature on the document, Mr. Hagerman. Thank you, sir. Mr. Marcus Johnson, good morning, sir. Mr. Johnson, what's your real name, sir?
Marcus Johnson.
You need to speak up a little bit louder. The court reporter here has to write down everything that's said. Of course, I need to speak up a little bit louder. You can take the mask down if you want to. Yes, sir.
Marcus Johnson.
Mr. Johnson, what school did you go to, sir?
To Woodley High School.
How far did you get in school?
12th grade.
Did you finish the 12th grade?
No, sir.
Did you ever get a GED, sir?
No, sir.
Can you read and write okay, Mr. Johnson?
Yes, sir.
Mr. Johnson, answer those questions because the law requires you to answer, okay?
Okay.
A couple of things, Mr. Johnson. You were charged by way of an indictment 2204769, charged with conspiracy to commit first-degree murder.
Yes, sir.
That Class A felony carried anywhere from 15 to 60 years in prison. You're pleading guilty on a superseding information, I-23-00019, that charged you with 3 counts of accessory after the fact. That's an E felony, carries up to 6 years in prison. You understand that, sir?
Yes, sir.
Mr. Johnson, you have a right to have this charge submitted to the grand jury. When you enter a guilty plea on this information, you're waiving. You're giving up your rights to have this case of accessory after the fact submitted to the grand jury. That case comes to court quicker when you plead on an information. The state will make you the best offer they will ever make on an information, but you're giving up. You're waiving your rights to have this case on an accessory submitted and reviewed by the grand jury. Do you understand that, sir?
Yes, sir.
Is that what you want to do, sir?
Yes, sir.
For the record, I would find that Mr. Corman and this court have advised Mr. Johnson has the right to have this charge of accessory after the fact reviewed by a grand jury. If the grand jury found probable cause, they would indict him. If they did not find probable cause, they would no deal this charge. And I'll find that Mr. Johnson has made that decision intelligently and knowingly. Mr. Johnson, I'm going to show you a document for the record. This is a petition for waiver of trial by jury and request for acceptance of the plea of guilty. On that bottom right-hand corner where it reads defendant, did you sign that, sir?
Yes, sir.
Mr. Johnson, all of your rights are above you're seeking to. Those are your state and federal constitutional rights. Did your attorney, Mr. Corman, go over those rights with you and explain them to you, sir?
Yes, sir.
Do you understand the rights that you're waiving and giving up today, sir?
Yes, sir.
Mr. Marcus Johnson, you heard Mr. Paul Hagerman, the prosecutor, recent statements in court a few minutes ago. When you enter this guilty plea, when you enter this change of plea today, you're telling the court that if you had a trial on your case, the state of Tennessee would bring witnesses to court. Those witnesses would testify under oath. They would say things that are similar, that are consistent with what the prosecutor just read. You're telling the court, Mr. Johnson, that if a jury believed those witnesses, that jury would have enough reason to find you guilty of accessory after the fact. You understand that?
Yes, sir.
You have an absolute right to have a trial on your case if you wanted one. You have a right to say, Judge Crawford, not guilty of anything, and I want a trial. Judge, I am demanding a trial. And had this case been tried, you would have a right to confront and cross-examine those witnesses against you. Say you have to bring those folks to court. You can look at them in person. They would sit right there on that chair on the witness stand where you're seated. Your lawyer, Mr. Corman, would question those folks to see whether or not they are telling the truth. If a jury did not believe those witnesses, or if that jury thought they were lying or mistaken, that jury would find you not guilty and I would dismiss your case. You understand that, sir?
Yes, sir.
Had you gone to trial in this case, Mr. Johnson, you would also have the right to present proof. You could put on witnesses if you wanted to. You could present evidence. You don't have to do anything at a trial ever. If you wanted to, and only if you wanted to, you can take that witness stand and you can testify. You can tell the jury what happened. You can tell the jury your side of the story. If you chose to remain silent and not say a single word, I would tell that jury they cannot hold it against you for any reason at all. Do you understand that, sir?
Yes, sir.
Mr. Johnson, had you gone to trial in this case, if you had any witnesses that could help you, your attorney, Mr. Corman, would send them a subpoena and have them come to court and testify for you. If your witnesses didn't show up, or if they just flat out refused to come to court, I would have those folks arrested by the sheriff. I would make your witnesses come in. I would make them testify. And if I had to, Mr. Johnson, I would put them in jail until your case was tried. Do you understand that, sir?
Yes, sir.
Had you gone to trial and had a jury found you guilty of anything, you can appeal any conviction the jury gave you. You can appeal any punishment that I gave you. The Court of Criminal Appeals would grant you a new trial or even dismiss your case if that court found mistakes had been made in your trial. If you could not afford an attorney, I would appoint someone for you free of charge to handle your appeal. Do you understand that, sir?
Yes, sir.
Mr. Marcus Johnson, when you enter this change of plea, when you enter this guilty plea, you waive, you give up all those rights, you ask this court to find you guilty without a trial. And Mr. Johnson, both sides are recommending that I do not sentence you today, that a delayed execution of these judgments is set this case for a sentencing hearing. And at that sentencing hearing, Mr. Johnson, you'll be sentenced somewhere between 6 and 12 years in prison. Now, is that the agreement you have to state in Tennessee, sir?
Yes, sir.
Mr. Johnson, you've been sworn to tell the truth. You understand that, sir?
Yes, sir.
Everything that you say under oath has to be true. If you do not tell the truth, the state could indict you for perjury. That carries up to 12 years in prison. Do you understand that, sir?
Yes, sir.
Before I continue with this guilty plea colloquy, Mr. Johnson, Mr. Hagerman has asked the court's permission to ask you some questions. You waive your right to remain silent when you enter this guilty plea. So listen to the questions that Mr. Hagerman asked of you, sir.
Yes, sir.
Make sure you answer those questions truthfully. You understand that?
Yes, sir.
If Mr. Hagerman and Ms. Mond said, Judge Coffey, we don't believe Mr. Jamarcus Johnson has been truthful, they're going to ask the court to vacate this guilty plea, will strike this guilty plea, and your case will go back to the same status as was before this information was found. You understand that, sir?
Yes, sir.
Any questions, sir?
Yes, sir.
Mr. Hagerman, you may proceed, sir.
Mr. Johnson, we have talked before, is that correct?
Yes, sir.
And when we talked, you told me about meeting with your half-brother, Justin. He's your half-brother, is that right?
Yes, sir.
You told me about meeting with your half-brother, Justin, about a week or so after the murder of Adolph Ford Jr., is that right?
Yes, sir.
You told me at that time that he gave you a car, is that right?
Yes, sir.
You told me at that time he also gave you his cellular telephone, is that correct?
Correct.
You told me that, or did you tell me that afterwards you used that cellular telephone at his request?
Yes, sir.
Did you describe to me a scenario in which you would place one phone up to another while Justin was on another phone for the benefit of his parole or probation officer?
He was called to get somebody's number, and I would put it to my phone
down on the bed, and I put somebody else's phone right there and let them talk to each other.
And you told me about the times that you did that, is that correct? And you also described times not just with the probation or parole officer, but also with an individual known to you as C.
Mm-hmm.
Is that correct?
Yes, sir.
And you now know that individual to be Cornelius Smith, is that
Yes,
right? And you described to me, and you turned this phone over, and in it were text messages with this individual C, is that correct?
Yes, sir.
And some of these text messages, some of what you witnessed was conversation with regard to money that Justin would be getting to C, is that correct?
He asked for money, yes, sir.
As for money,
Yes, sir.
is that correct?
Yeah. He was asking for money for somebody else, from somebody else.
Okay, and that somebody else was referred to as Unc, is that correct?
Yes, sir.
Okay, so this would be money that C asked for from Justin that Justin was going to get from Unc.
Yes, sir.
Is that correct? You described all that to me.
Yes, sir.
You've also looked at some photographs that included one of your half-brother in a particular outfit, and you identified Justin Johnson, your half-brother, in the photograph.
Yes, sir.
Do you understand that one day you may be called to testify in a trial on this matter?
Yes, sir.
Will you tell the truth at that time?
Yes, sir.
Have you told the truth with me?
Yes, sir.
No further questions, Judge.
Thank you, Ms. Hagerman. Mr. Corbin, you have any questions of DeMarcus Johnson?
No question. Thank you, Judge.
Mr. Marcus Johnson, the felonies that you pled guilty to, accessory after the fact, is a Class E felony. It carries anywhere technically from 1 day to 6 years in prison. You understand that, sir?
Yes, sir.
You have agreed under what's called a hybrid guilty plea, State versus Mailer and Hicks, State versus Hicks, in which you're agreeing to plead outside of your range. You're not a range 2 offender. You understand that? In order to be a range 2 offender, you have to have 2 prior felony convictions. You don't have any felony convictions. You understand that? You can agree to plead outside of your range as long as it's within the range of punishment for that crime, that E felony, as long as you're doing that in your best interest. You understand that? So you agree to plead outside of your range as a multiple range 2 offender. And that range 2 sentence will carry anywhere from 2 to 4 years in prison. And you've also agreed that at your sentencing hearing, you will be sentenced to consecutive sentences on these 3 counts. So it's a minimum sentence of 6 years in prison to as much as 12 years in prison. Do you understand that, sir? You understand normally, unless you make that agreement, you cannot be sentenced to more than 2 years in prison. If they were ranked consecutive, it would be a total sentence of 6. Do you understand that? Mr. Johnson, once the court sentences you, you lose all of your rights to citizenship. You understand that, sir?
Yes, sir.
If you're sentenced on this case, in order to serve the sentence in prison, you'll be a convicted felon. That felony conviction will be on your record forever. You understand that, sir?
Yes, sir.
If you were sentenced to a penitentiary sentence, even placed on probation, would have to render you infamous. For the rest of your life, you would lose all of your rights to citizenship. Then since you lose the right to vote, you cannot vote until you completed that sentence, and the right to vote was restored or given back to you by a judge in circuit court or by a certificate from the Tennessee Department of Corrections. Do you understand that, sir? As a convicted felon, Mr. Johnson, you could never serve on a trial jury. You can never possess. You can never carry. You can never buy. You can never own any handguns, firearms, rifles, shotguns, pistols, ammunition, or even a bullet. Mr. Johnson, if you had in your possession, in your hands, in your pockets, on a house or car or any other place, if you possess any firearms, if you have one single bullet in your possession, United States prosecution federal court, unlawfully possessing a firearm as a convicted felon, you can be sentenced to federal penitentiary for a long time. If you possess any handgun or firearm, Tennessee can prosecute you for that. That carries up to 30 years in state prison. Do you understand that, sir?
Yes, sir.
Again, you've been sworn to tell the truth, and everything that you say has to be true. You understand that, sir?
Yes, sir.
Do you have any questions about the rights that you waived, the guilty plea you entered, or this agreement you have with the state of Tennessee, Mr. Jamarcus Johnson?
No, sir.
Have any complaints about anything that Mr. Corman has done since he's been your lawyer, sir?
Yes, sir.
How long has Mr. Corman been your lawyer, Mr. Johnson?
8 months.
Did he get this 7 months? Did he get discovery for you?
Yes, sir.
Did he let you know what to say would try to prove if you had a trial?
Yes, sir.
Did you have anything that you wanted Mr. Corman to investigate for you?
No, sir.
Do you have any complaints at all about anything that Mr. Corman has done or has not done since he's been your lawyer?
No, sir.
Do you also understand, Mr. Johnson, that part of this agreement, this memorandum, adopted by the parties, will be filed as a public record with your guilty plea? You're pleading guilty to those 3 counts of that information. You're also agreeing that you be sentenced as a range 2 offender, even though you are, in fact, only a range 1 offender. You understand that? You also are agreeing that those 3 felony convictions will be served consecutively to each other or one another, making that an effective sentence of minimum of 6 years to as much as 12 years in prison. You've also agreed that the state of Tennessee has not made you any promises, no recommendations to your sentence other than they would detail to the court any cooperation and truthful testimony or statements that you have given that may have aided in the prosecution. As Mr. Hagerman just told you, if some of those other cases go to trial, Justin Johnson or Cornelia Smith or Hernandez Govan, if those cases go to trial, the state of Tennessee might actually call you as a witness. You understand that? You understand you waive your right to remain silent, and you could in fact be compelled to testify if those other cases are tried. You'll also be supervised by Shelby County Pretrial Services. They reporting all parties recommending that you be released on bond in an amount of $25,000. And once you make that bond, Mr. Johnson, you have to report to Shelby County Pretrial Services. They're reporting. We'll file that order with this guilty plea also. You have a curfew from 9 o'clock at night until 5 o'clock in the morning. You have to be at home every day, all day, until your case is disposed of, unless you are working. I want to encourage you to work, and if you are working, you have to provide to pretrial services proof that you are in fact working. Otherwise, from 9 o'clock at night until 5 o'clock in the morning, you have to be at home every day, every night. You understand that? You'll also be in order to enroll in any other programs that pretrial services deem either group programs, individual programs, such as random drug screens. You have to check in with these folks automatically, regular contact with the person who supervises bond. And you also cannot possess a firearm while this case is pending and while sentencing is pending. You understand that, sir? You have any questions about any of those conditions that we talked about? Mr. Marcus Johnson, I'm going to find for the record that Attorney Mr. Joshua Corman has represented you satisfactorily. I find that Mr. Corman and this court have explained all your rights to you. I find that you understand those rights and that you waived it. You've given up those rights intelligently and knowingly. I do find that there is a factual basis. There is a legally sufficient reason for this guilty plea, which has been entered freely and voluntarily. And upon you plead guilty to information I-23-00019, counts 1, 2, and 3, Class E felonies of accessory after the fact, Mr. Johnson, it is a judgment of this court that you are guilty. The court is going to delay the execution of these judgments. It will delay a sentence on this case until Ms. Corman, Ms. Mine, Mr. Hageman, do you have a recommended date for the next setting on this case?
We get about 45, or somewhere between 45, about 60 days.
The 60 days is August 10th, Thursday, August 10th, is the day for all Warriors.
That's a good day, Judge. Thank you.
Yes, sir. Mr. Johnson, we're going to delay the execution of these judgments. We're going to delay the sentencing on this case to a sentencing hearing on August 10th, 2023. Be back in this courtroom at 9 o'clock that morning, unless that date changes, and stay in touch with Mr. Corman in case the date does change. But I'll see you back in court on August 10th, that's a Thursday, at 9 o'clock that morning. Make sure you go to pretrial services on Tuesday morning. They will not be open on, they will be open on Monday. We won't be in court on Monday. Go to pretrial services on Monday morning, June the 12th, at 9 o'clock. They're on the 8th floor in this building. One of the deputies will make a copy of the pretrial pretrial day reporting order for you. Take that with you. Go talk to those folks Monday morning at 9 o'clock. They will supervise this bond. Make sure you maintain contact with them. Make sure you answer those calls and those curfews. And make sure you submit to those random drug screens, because that will be required as a condition of this bond. Stay out of trouble. Don't get yourself arrested again. Be safe. And I'll see you back in court on Thursday morning, August the, I think it said August 9th, Thursday morning, August 10th. Thursday morning, August 10th at 9 o'clock. Any questions, sir?
No, sir.
Mr. Johnson, step down from the witness stand and see you in 2 months, sir. Thank you, sir. Mr. Hagerman and Ms. Mine.
Yes, sir.
The indicted case 2204769, do you want to dispose of that today or carry it?
I'm sure we set to that same date, Your Honor.
Madam Clerk, show the other case 2204769 set for report on Thursday, August the 10th.
If the, Ms. Clerk could make a note that the bond that Your Honor set covers both cases.
The bond $25,000 covers August case, the information case, and the indicted case 2204769. I don't know if the bond was on that case, but show the bond, a collected global bond of $25,000 to cover both cases. Anything else we need to address on this case?
No, Your Honor, thank you.
Ms. Corbin, Ms. Miles, Mr. Hagerman, thank you all. Mr. Johnson, I see you on August 10th. Stay out of trouble, sir. Be safe. We'll get that copy of the order to you in a few minutes, okay? Thank you, sir. Yes, ma'am.